bringing you a steady stream of thought-provoking ideas and cutting-edge innovation. You're listening to Society and the State. Life, liberty, and your pursuit of happiness. Now, your hosts, Connor Boyack and Brian Hyde.
Welcome to Society and the State. Connor Boyack is here along with yours truly, Brian Hyde. And this is such a great topic we have today. Rebecca Brown is the Director of Policy for the Innocence Project. And Rebecca, we are so glad to have you on our Society and the State podcast. To start with, I think most of us grew up believing that, our justice system is the one thing we can count on to make sure that the right thing happens, the fair thing happens. But sometimes there are some very definite problems, and I don't think any group has let out in highlighting some of the injustices that have come up through the justice system, like the Innocence Project. Tell us a little bit about your organization and about how it began.
Absolutely. And let me just say it's a real pleasure to join you today. So thanks for having me. So the Innocence Project's mission is to free the staggering number of innocent people who remain unjustly incarcerated because they've been wrongfully convicted, and also to bring reform to the system responsible for their unjust imprisonment. And I think a lot of what you just raised really touches on sort of the core of our mission, right? Is the notion that our system, like all systems really, is a human system and therefore fallible. And unfortunately, during the course of litigating many of these innocence cases, we've learned just how fallible. And I think, it really is quite shocking to a lot of people just how fallible that system is. To date, we've proven the innocence of 351 people using DNA technology. And the National Registry of Exonerations, which tracks both DNA and non-DNA cases, has revealed more than 2,000 cases in America of wrongful conviction based on actual innocence. So, we are seeing that this is, in fact, quite a fallible system. And a lot of our mission is really doing what we can to prevent future miscarriages of justice.
Rebecca, I watched one of the Lord of the Rings movies the other day, and this is a bad analogy, but it's useful, so I'm going to use it, where when they were approaching the Tower of Sauron, and he had the eye that was casting down upon the valley below, and Frodo and Sam could continue towards Mordor provided that the eye was not looking at them. And I bring that up because it makes me think that with your work and the statistics you just shared, those are the cases that you've had your eyes on. But there are many other cases that you guys have not been able to review, whether it's lack of funding or priority or DNA evidence that can be tested, for DNA and so forth. And so correct me if I'm wrong, but I guess my impression would be that that's a staggering figure just for cases that you guys have given attention to. But are there other cases that have been outside of the Innocence Project's view for now? And so the numbers that you share, staggering though they may be, are potentially a small percentage of what could be a large number of innocent people in the entire system who also, deserve our help and resources to liberate them and so forth. Am I wrong in that assumption?
You are absolutely spot on. I mean, I think that, when you look at DNA exonerations, that is the tip of the wrongful conviction iceberg. Criminalists estimate that DNA is available in well under 10% of cases to prove guilt or innocence. So, in fact, it's a small universe of cases where DNA can prove guilt or innocence. There are a limited number of litigators that are working in a post-conviction setting to begin with. So, it's not as though we have, huge numbers of lawyers dedicated to litigating post-conviction claims of innocence. So there's certainly a resource issue. And, our office, for instance, now only takes cases where DNA could prove guilt or innocence. There are other projects in our Innocence Network, including the Rocky Mountain Innocence Center, which is a phenomenal project, which looks at non-DNA cases as well. But I mention this just to say that, people often think of DNA as sort of the gold standard, which it is. But, there are many, many cases that would never benefit from DNA testing because there's no DNA evidence to test. And you touched on another important issue, which is that a lot of biological evidence has been destroyed in these old cases, simply because governments didn't anticipate the probative value of DNA. So they destroyed or lost a lot of this very important evidence that could prove innocence. So there are a lot of limitations in revealing wrongful convictions. And I think the other thing to really point out here, which I think often gets lost, is the fact that we have a huge system, right? The United States incarcerates like no other country. So we now have 2.3 million people behind bars. And because of that, it's important to remember that, we're only talking about serious violent felony cases. We know from our DNA-based exonerations that 10% of our clients who were largely proven guilty of rape and murder pled guilty to those crimes. So when you think about when the pressure is less and the stakes aren't as high, how many innocent people are likely pleading to low-level crimes or lower-level crimes where the sentence lengths aren't as extensive but are still, going to, really interrupt or ruin people's lives. These are major problems. And we have a plea-based system. And so we know that plea-based system is compelling a lot of innocent people to, in fact, plead guilty to crimes they did not commit.
And that's one of the more compelling things I've seen recently is not only studies, but specific cases where factually innocent individuals in the hot box, in the office with the detective, right? They're basically being persuaded to plead guilty to a crime that they did not commit because it would have a more favorable outcome for them or for the victim's family, or they're psychologically eventually led to believe after hours of interrogation that maybe they're confused and maybe they did in fact do it, right? And I just want to get out of here and go home, so sure, I'll go ahead and plead guilty. And so even in the cases where they plead guilty, it seems you're suggesting that there are innocent people there as well.
There's no question. And you hit on a lot of the reasons why. And I think a very interesting and important reason why also is that people who know that they're actually innocent plead guilty all the time because it is a rational choice given what they are facing. They, don't have confidence in the system. They, often come from communities where they have seen a lot of innocent people plead guilty to crimes they didn't commit. They don't believe that the system is going to really sort it out properly. And I think for the more serious crimes, what I think is fascinating is that innocent people don't seek the same protections that guilty people do. So, for instance, before they are interrogated, they don't ask for a lawyer because they believe it's going to be sorted out during the course of questioning. But unfortunately, they don't get the protections that would be offered by having counsel present, and they end up sometimes confessing to crimes they didn't commit. We know that 28% of the nation's 350-plus DNA-based exonerees either falsely confessed or pled guilty to crimes they didn't commit.
Wow.
And a lot of these people were perfectly mentally capable adults. I mean, obviously, juveniles and people with mental limitations are more vulnerable, more susceptible. But in fact, totally mentally capable adults plead guilty and confess to crimes they didn't commit because of all sorts of reasons, from coercion to fear of a harsher punishment to really believing that, they're going to go down for this anyway, so they'd rather get the least amount of time.
So, Rebecca, where does reform begin? You mentioned earlier that we're dealing with a massive system. There are more laws than any one of us can name. There are judicial practices. There is just an entire system that seems overwhelming. Where's the most meaningful reform likely to have an effect?
Right. So a lot of our focus has been, twofold. One is revealing wrongful convictions, simply to, spare the people who are already behind bars, and get their freedom. So a lot of what we do is work on making fixes to post-conviction DNA testing laws to enable all innocent people who are, wrongfully convicted to seek testing and create statutory mechanisms for people to get back into court when science changes or our understanding of science changes, or when experts repudiate past testimony. When they, for instance, if a hair analyst, got on the stand and said this is a match 20 years ago and today would repudiate that testimony, often people are blocked from getting back into court to prove it because of how the statutes are constructed. So we are going back into many states to create mechanisms so that people can prove their innocence without the benefit of DNA. And in terms of preventing wrongful convictions from happening in the first place, there are a slew of reforms that we work on. One is eyewitness identification reform. We know from DNA-based cases that it's the single largest cause of wrongful conviction of DNA-based cases. For instance, requiring that the person administering a lineup does not know the suspect's identity so that he or she is not in a position to provide any suggestion to the witness is a key reform. Recording custodial interrogations is a key reform that we promote around the country because it really shows what took place or transpired in the interrogation room, so that if somebody provides a false confession, that videotape can be reviewed. And, we've seen instances where law enforcement unintentionally fed facts about a crime to an innocent person being interrogated, and then that person parrots that information back to law enforcement, and it appears that they're providing information that only the perpetrator would know. If you have a videotape of what took place in the interrogation room, you can go back, review it, and identify where that happened. We're also very interested in regulating incentivized witnesses. So, for instance, jailhouse informants are not an uncommon feature in wrongful convictions. Over 15% of our cases involved a jailhouse informant coming forward and saying that, the defendant, in fact, confessed to them behind, while they were detained in jail together, that they actually did this murder. And of course, when you think about how frequent someone would turn to their cellmate after knowing them for hours and confessing to a murder, it's not, that credible. So one of the things that we are looking to do is to make sure that prosecutors are tracking the use of these informants. How many cases did they provide testimony in? What was their criminal history? Important facts that need to be shared with the defense so that, the reliability of that witness can be properly assessed. And of course, really working on a lot of issues around research and standards setting for forensics. We know that the misapplication of forensic science plagued about half of our wrongful conviction cases proven by DNA. So we're advocating, for mechanisms that facilitate the discovery of errors when they happen, the duty to correct those errors by addressing system-level causes and audits, and really making sure that defendants are notified in the face of those issues. So,
Rebecca, I want to jump in right there because this, to me, is a very compelling point, and to kind of buttress the point and then throw a question back at you, I'm going to read from a Washington Post article that came out about 2.5 years ago. We'll link to it, I should mention, for our listeners on today's show notes page, which is societyandthestate.com/49. And this article is titled FBI Admits Flaws in Hair Analysis Over Decades. It cites research and studying that your organization was doing along with the National Association of Criminal Defense Lawyers. And it says this, it says of 28 examiners within the FBI laboratory's microscopic hair comparison unit, 26 of them overstated forensic matches in ways that favored prosecutors in more than 95% of the 268 trials reviewed so far as of 2.5 years ago by your organizations. The cases include those of 32 defendants sentenced to death. Of those, 14 have already been executed or died in prison. And to me, I remember how explosive this was when it came out a couple years ago, because as Brian kind of led on the episode, there's this presumption of justice in the justice system, and that the science is accurate, and that these do-gooder federal prosecutors are using the right evidence the right way, and so on and so forth. And yet this analysis seems to turn that entire theory up on its head and say there is so much potential for not only fraud, deception, but even just human fallibility, if that's what's at play in some of this. Some FBI hair analyst's ego to kind of talk big and make it appear that they know more than they actually do, but that when this data at the end of the day is leading to not only incarceration but execution, that's very staggering. So maybe help our listeners understand, in the past 2.5 years, has more study like this been done? Is the trend the same? Is this kind of a very widespread problem for which we do need some of the solutions that you were just offering in terms of policy?
Well, absolutely. And, one of the things I alluded to before, and one of the things that we're working on in the policy department, is creating mechanisms so that old convictions can be revisited that are based on, forensic changes or changes in our understanding of forensics, like microscopic hair comparison analysis. And so the project that you're referring to, I believe that there were about 800 cases that have been reviewed thus far. And we do know back in 2015, so this is before we had reached the 1800 mark, but back then, the FBI had concluded themselves that their examiners' testimonies in over 90% of trial transcripts contained erroneous statements. Now, whether that meant that the person was guilty or innocent is something different from that. But what we do know is that there were erroneous statements. And I think, one of the things to bear in mind when we think about, erroneous statements being made by forensic analysts is when you look at a wrongful conviction case, when you do sort of a postmortem of a wrongful conviction case, it's not usually just one thing that went wrong. It's usually many things that went wrong. So when you look at the case, it looks like all of these things, pointed to guilt, right? Somebody, you had a statement from a hair examiner, you had a false confession or a confession, from the defendant. You might have had an eyewitness identification. But later, when the DNA testing is done, for instance, of that microscopic hair, and it shows that, in fact, the defendant is excluded, then you come to find out that, in fact, the confession was false, and you come to find out that the person was misidentified. So, it is a human system. It's comprised of people, and it shouldn't surprise us, therefore, that, mistakes happen, and, of course, misconduct happens. And so, what often looks like just this huge amount of evidence often amounts to kind of a house of cards. And so it's very important that we do everything we can to get all of these pieces correct, because, of course, just one of these things going wrong can lead to a wrongful conviction.
Rebecca, one of the most powerful things I've noticed in going through the Innocence Project website is you link up actual people, actual stories to what's at stake here. The statistics are pretty staggering. And for people who are driven by numbers, it's certainly going to get their attentions. But nothing seems to sway people, or at least open their eyes, like knowing, wait, that's a real person that we're talking about. Are there any stories in the 25-year history of the Innocence Project that you would consider must-hear stories for those who may be willing to delve a little further into it?
Absolutely. There are so many. Every one of these stories is compelling in a different way. I think the Michael Morton case out of Texas is fascinating because just so much went wrong. This man was wrongfully convicted of murdering his wife, and their 3-year-old son was actually a witness to the crime. That child had actually told law enforcement that a monster had committed the crime. The child observed the crime, and that daddy was not home when the murder occurred, and that was suppressed. That wasn't handed over to the defense. And so defense lawyers didn't really learn of this information until post-conviction. And so, obviously a case of extreme misconduct, but, there were a host of other issues that went wrong in his case. And I think one of the reasons why it's a great case to read about is because it really led to a slew of reforms in the state of Texas, the most important of which was probably what is called the Michael Morton Act, which led to discovery reform, making sure that key evidence is disclosed to the defense. And that is now law in the state of Texas and, frankly, a model for the country. So I think, it's a great case to review because you can see kind of all of the pieces that went wrong. But it's also a great case to look at because it led to so much good in the state of Texas. And it really is the gold standard law.
So
in the country.
In Michael Morton's case, correct me if I'm wrong, but I believe that he was sentenced to life, right? Like that was not a death penalty case. Am I remembering that right?
I believe that that's correct.
And so my question, I guess, relates to the Innocence Project stand on the death penalty, because in my mind, if we're executing people that are actually innocent and perhaps their innocence is, discovered some years later, which is probably unlikely because who's going to invest the resources to inquire about a person's innocence who is deceased already, right? Like there's no opportunity for, liberating that person from prison. So the incentive is no longer there to invest all the resources. Nonetheless, in my mind, the biggest problem that we face with everything that you've brought up, especially the fact that it's a system run by humans, which means there's fallibility throughout. In my mind, it seems essential that to support the work of liberating people who are actually innocent but who have been incarcerated and convicted of these crimes they did not commit. It seems essential that the capital punishment as an option cannot stand because it forecloses the option to liberate people that you later discover are innocent. So my question is that the policy of the Innocence Project? How strongly does your organization support repeal of the death penalty? And would your position be more just in favor of life without parole so that those people are still sitting there if, in fact, you're able to prove their innocence and liberate them from prison?
Sure. So, I think, the stance of our organization, our policy position is that we call for the moratoria of all death penalties at the state level until and basically the basis for that is that until a state can assure that all of the evidence that it's presenting is airtight, you really can't have a death penalty. So, for instance, I think good people can differ about the morality of the death penalty, in a perfect, pure system. But I think given the fallibility of the system and just how little many states have done to really prevent wrongful conviction, it's totally irresponsible to have a death penalty and unconscionable, frankly, because, it will lead to innocents being put to death.
Rebecca, for people who want to become better informed on this, where do you suggest they direct their attention?
Sure. They are welcome to look at our website, innocenceproject.org. There is a section of our website that talks about all of the reforms that we're seeking. And also people can take a look at how their state stacks up with respect to innocence reform. How do they have a robust law that provides access to DNA testing and other access to proving innocence? Do they have a state law to compensate the wrongfully convicted? What have they done with respect to police practice? Do they have lineup reform? Do they record interrogations? All of that information can be found on our website for folks that want to learn more.
Just one final question for you. In your work and as the Innocence Project moves forward, do you find that there are still people who cling to the idea that, but it could never happen to me? How do you break through the fog that, or the limited sight that people have that says they could never find themselves in a situation like this?
It's interesting. I think it's rare that somebody says that, but I think, there's often, I think it's probably one of the most horrifying things that someone could imagine. It's almost Kafkaesque, to kind of believe that you'll wake up one day behind bars for something that you didn't do. And so there might be almost a willful ignorance about it because it's just too horrifying to imagine. But I think that, we have such a large system at this point that there are few people that aren't touched in some way by the criminal justice system. Somebody knows somebody has a friend or a cousin, and they're not necessarily touched by wrongful conviction. But I think, because our system is so vast, people are just becoming more and more educated about this, how large the system is and just how fallible it actually is as well.
Okay, we've been visiting with Rebecca Brown, who is Policy Director for the Innocence Project. Those who'd like to follow up, we will have links posted on this website, or on our podcast, rather, which is societyandthestate.com/49. Rebecca, thank you so much for the work you're doing and for taking time to visit with us.
Thank you. It's been a pleasure.
You've been listening to Society and the State. For show notes, archives, and more great content, visit societyandthestate.com.